Hello, friends. We welcome you to the Legal Breeze. Today, we will like to discuss about certain interesting factors relating to the basic structure theory um proposed by the Supreme Court of India, as it is what is known today. What is this speciality of basic structure? How it has come, and why people like me, academicians, have to speak about it? What is the contributions made by the academicians in the formulation of this famous theory or doctrine known as basic structure? Whether it has really safeguarded the constitutional edifice of this country, what are the improvements needed? All these things will be discussed in this particular video is concerned. Before I do that, I think I have to express my sincere gratitude to my student editor, Ms. Nishasri, who is really extremely helpful in collecting the necessary data. We will also like to acknowledge Hindu and the writers who have made enormous contribution on this aspect through their writings. Now let me come back to this basic structure. All of us well known, or it is well known to all of us, that Golaknath case is a precursor to the Kesavananda Bharati case. 24th April 1972 is a landmark day. People equate this decision with Marbury versus Madison, a story which is popularly known for the doctrine of judicial review. Particularly, we remember the contribution made by C.J. Marshall, but we all forget that the contribution made by C.J. Koch is equally important as it is. But many a times people used to say, when the revolution is successful, it becomes legal. Victor justice theory. Any theory which is become victorious, we remember that. But something falling short of victory, we forget this. Attempt has been made in Golaknath case itself so as to restrain the parliament from amending at least the important portions of the constitution, including the fundamental rights. But somehow it has not reached that stage. But in Kesavananda Bharati case, because fundamental rights has been made as explicit restriction, there are two types of restrictions imposed by the constitution upon the inherent power of the parliament to amend the constitution, which is included in the Indian constitution. And we have also, please remember, the amendment, there are three types of amendment. One is by simple majority, another by special majority, the last one, special majority with the ratification from the states. At least 50% states should ratify it. The last portion of Article 368, or the third mode, what we call it, has been borrowed from the United States of America. In the US Constitution, there are three things which have been made explicitly not amendable by the Congress of US. But in spite of this explicit limitation or express limitation, two has been amended even today, and that has been approved by their own apex court. But only one thing remains as unamended, that is the representation to the Senate. Thereby, they are able to preserve the sovereign equality of the states. Today, after 2026, in India also we are going to face a huge phenomenal problem because of the population issues. Many states, that is going to change the entire equilibrium of the states in this country is concerned. People are proposing, should we have such a model, at least to give equality of status in the Council of States, Rajya Sabha. But anyhow, let me come back to this story. So likewise, Article 13 1 and 13 2 has made certain explicit or express limitation or valid fetters upon the power of the parliament to amend the constitution. To that extent, it is very clear. But apart from that, is there no other implied limitation? That is the crux of basic structure. How it has come? Way back in 1965, this is very important. BHU, Banaras Hindu University, even today it is one of the renowned university. They have invited a Germanian scholar whose name is Dietrich Comrade. He is a great scholar for whom we all owe greater amount of gratitude, and we are indebted to him highly because he is a proponent of this particular doctrine called basic structure theory, because whatever they have experienced in German, that was the outcome of this particular formulation, what he has proposed. So what he has foreseen has exactly happened in India, and whatever he has delivered as a lecture, that lecture was prepared in the form of an article, and it has been sent to Madras University, Department of Legal Studies. At that point of time, it was headed by Professor Ramarao. Again, he is a renowned scholar. We should be thankful to Almighty. We are all part and parcel of this academic fraternity. We are all hailing from that Department of Legal Studies. It's a very prestigious one. I think we all should do our bit to regain the glory of that particular department. There is one journal called International Year of Indian Yearbook of International Law. In that journal, this lecture was published as an article. So this is the basic crux, and this attention has been devoted by the then popular lawyer called Nambiar. I think he is father of Sri K.K. Venugopal today. So he has popularized this, and of course later on it was picked up by Nani Palkiwala, and he has successfully articulated this in Kesavananda Bharati case. And we all know Justice Khanna's contribution in ADM Jabalpur case, a vital contribution. Equally here also, the court was divided 6-6. That is, it was a 13-judge bench. Please remember this. 6 judges made it very clear the parliament can and shall amend everything. There is no express or implied limitation at all. Equally, the other 6 judges have divided. No, parliament cannot amend and shall not amend everything. There is an implied limitation. But who tilted this balance is Justice Khanna, who said, yes, there is no doubt parliament can amend everything, but it doesn't mean that there is no implied limitation. So the parliament is also governed by implied limitations in certain occasions. That is how he tilted the balance. Now 7-6, just by a thin majority, just by one judge. This formula or theory, doctrine stays today. It was successfully tested once again in Indira Rajanarayanan case. Again, the aforestated academician, jurist, eminent jurist, or distinguished jurist, whatever you call him, Professor Dietrich Comrade has visited Delhi way back in 1990s, and he has said many interesting stories how this basic structure theory has been exported to Bangladesh. And there is a case, I think, Anub Rahman versus Bangladesh. There the Supreme Court of Bangladesh has successfully applied this. Though Pakistan doesn't use the term, but they have also come very closer. Still that institute is very much available in Delhi. That institute name is Indian Law Institute, ILI. And there is one association called United Lawyers Association, They publish a journal called Law and Justice. In that journal, again, this idea has been published. And after IR Kahalo case, it has gone beyond even the ninth schedule. Even they have successfully struck down the NJAC 99th constitutional amendment using the basic structure. However, there are certain things which have been conveniently forgotten by the Supreme Court, though they have declared certain things as basic structure theory or forming part of basic structure. The glaring example is socialism. Socialism is totally forgotten today. People may call it inclusive growth or sustainable growth is the new name for the socialism. But again, we need a clarification whether actually speaking that is not one and the same. Only because this is something equity, inclusive growth, and not equality. Socialism is again socialism not only a basic structure. We have also covered directive principles as basic structure, fundamental rights as a basic structure. But we need to apply our mind very carefully, and academicians need to work out to highlight many things. And this is a contribution made by the academicians, but unfortunately, their role is not credited. They are not recognized. Their efforts are not being portrayed. I don't say the credit shall not be given to the judges or lawyers. It has to be, it could be and shall be given it to them. But equally, they have to acknowledge the contributions made by the academicians. Unfortunately, today it is not the case. People recognize even the law students' role, but they forget law professors' role. This is very unfortunate in the Indian scenario. We believe these things will change. Change will come sooner rather than later. The good sense will prevail, and academicians will get their due recognition in the administration of justice. Otherwise, Article 124, subclass 3, class C will become meaningless. Let us hope such a day comes sooner rather than later. God bless you all. Thank you. Jai Hind.